untouchable, a sense that needs, in my opinion, to be really shaken. For me, the long arm of the law needs to feel a few white colours here. So on that, you've indicated fairly clearly that you do not intend to call the Gardaí in, but if I heard you correctly, you indicated that should other agencies wish to discuss the report with you, that you would be satisfied to do so. So you also indicated that you have had a tentative engagement with some, which implies more than one. So with whom have the central bank had these tentative engagements, and do they include An Garda Síochána?
So, Deputy, I apologise if you got an impression of passive conduct on my part. That does a disservice to our actions. I confirm that in the course of this very meticulous and careful investigation, we did not form suspicion to support reports to other agencies. But, Deputy, we have published very detailed enforcement outcome only last week, and following on that, which put the information into the public domain, we have been in contact with various agencies who I will not name. They would not wish me to do so, and I will not. But I absolutely intend to have a proactive discussion with a number of agencies about this, including An Garda Síochána and the Office of the Director of Corporate Enforcement, to sit down with them in the full facts of the information so that from their perspective they can consider this matter. And I just want to make an observation at a general level, which is we are in regular and excellent contact, for example, with An Garda Síochána, right across a number of issues. We find them proactive and responsive, and I would like them to report of us in the same way. We are both part of the Hamilton Group, which is a group that has been put in place to make recommendations about the improvement, if I call it in my language, white-collar crime issues, with a number of recommendations about an expert advisory committee for a...
Okay, but to be clear, I just want to be clear on this, that since the publication of the report, you have had a tentative engagement with more than one agency, and also you intend to sit down and to discuss with the Office of Corporate Enforcement and with An Garda Síochána, not issues right across the financial sector, but the specifics of this particular report into Davies. Am I correct in that?
Yes.
Okay, my second question. The deal involved here, I think, was 2014, thereabouts. It's now 2021. So the 16 individuals have been involved here for a period of 7 years since then. And the question arises as to whether this was an exceptional case, or might there have been other cases in the course of those 7 years. That would seem to me to be a strong argument for opening up the books and for going through the Davy books for the last 7 years at least with a fine-tooth comb. Have you done this? And if not, why not?
So, Deputy, the enforcement outcome is the conclusion of a meticulous enforcement investigation that runs in parallel to intrusive supervision. The Central Bank of Ireland cannot usually comment on our actions in supervision, but because Davies themselves have publicly confirmed that significant changes have already happened in terms of their own actions, in terms of governance, risk management, addressing these issues, I can tell you that the Central Bank of Ireland, it is not by an accident that those issues have occurred. And as is usual in supervision, we demand that these matters are addressed. And I can't get into detail around specifics more than that. In fact, we've provided a significant amount of detail about this case in the course of this focused series of questions. And I am happy to confirm that this is a high priority for us. It is a dynamic regulatory context. We have put out only last week the detail.
I understand that.
Supervision is intrusive.
I understand. I merely seek clarification on one point, okay? And the point is this, that you have conducted an exhaustive investigation over a whole number of years into a particular deal, a particular case. Now, my question is, has there been an investigation, not by Davies, but by the central bank, into the possibility of other such deals, perhaps, involving those 16 individuals, perhaps, within the company over the last 7 years, or have you left that to Davy to check into?
So the enforcement case only reports on the breaches that we have found. And that is how that is dealt with. And we put that into the public domain. Our supervisory work that the separate supervision team does alongside of these issues is not something we can report on into the public domain. But what I can tell you is generally, when we find issues in firms, we engage with them in a very challenging way to look at the issue, to demand that they fix the issue, and the staff of the central bank will use their own skillfulness to scrutinise those issues and even do things like appoint, for example, external persons to look at those issues and to demand that they are looked at. The enforcement case only reports on these specific narrow breaches of issues. Perhaps my colleague Ed Sibley might give you a bit more information about the supervisory approach.
I actually want to come in and ask my next question because the time I have available to me is limited, so sorry for that. So you've made it clear in the course of the engagement that you are not prepared to name the 16 individuals, and you've kind of indicated that there might be legal issues with you doing so as well, all right? You've indicated that if and when they leave Davies, that where they go, that their new employers have a responsibility in that situation. But the question is, do the clients that are served by such a financial institution not have rights as well? For example, to bring it down to brass tacks, I have an investment in a pension fund, for argument's sake, and that pension fund is with a financial institution. And one of these 16 individuals transfers over and gets new employment in that institution. Should I not have a right to know that that's the person that's managing my pension fund? Or is it solely a matter for the CEO of the company or the board of the company to take care over who they're employing? Should I not have a right to know who's in charge of my money there?
So, Deputy, because people who are entrusted to run financial services firms, it really matters. It matters to the consumers and the investors. There is a very careful system of pre-approval which you are not entitled or permitted to take up a senior role in a financial services company unless the firm itself proposes you, but then it has to be approved by the Central Bank of Ireland. So it's not simply a decision of a firm or a COO, but of course it's very important to recognise their obligations, that anybody who is running a business must take the responsibility for making sure that people that they employ are fit to do the work to serve investors and consumers. But there's additional safeguards with respect to nobody is allowed to take up a position of a senior role in financial services. There's a list of those positions and those roles without approval from the central bank, precisely because, as you say, it is very important that the investors are protected from individuals. So the system is designed with that in mind. And Deputy, it is we can only name people where the law allows us to do so. Otherwise, we ourselves would be breaking the law if we ignored those safeguards that are in place.
Seems to me that it's possible that one of those people could end up managing my pension fund. It's not in my hands. It's in the hands of the central bank and the heads of the financial services company. But then just to finish on that particular point, these 16 individuals held, and I presume still hold, a large number of shares in Davy. In fact, probably a controlling share of Davy. They may be forced to move on to other companies, but are you in a position to compel them to get rid of those shares? Or could it be the case that those 16 individuals would still have a controlling share in this company? Is that theoretically possible?
So, Deputy, I can tell you that the central bank takes its responsibilities seriously, and we will and are engaged in very live supervisory work on this case. All proper responsibilities will be discharged by us. As a general matter, the central bank takes very seriously its responsibilities for people working in firms, that they are fit and proper. And when we look at the authorisation of firms, there are certain criteria that we have to look at as well. And there are certain criteria around shareholding ownership that reaches thresholds with specific factors. All of that is set out in a legislative scheme, and the central bank will discharge its obligations fully and properly. It is true that there can be situations where firms are part of a wider group structure. Some parts of that structure might not be regulated in financial services. It might have unregulated business, and there may be shareholdings to do with that that is outside of the scope. But, Deputy, we will take our obligations fully and seriously, as we do. As I say, we have demonstrated through following this action through to holding Davies to account in public.
Sorry, if I could just...
Thank you, Deputy.
Could I just supplement?